Employees often come to me who are involved in a workplace investigation or disciplinary, and there may well be statements made in the course of the investigation or in the course of the disciplinary with which they are not happy. In fact, they are intensely unhappy, and they invariably inquire about the possibility of suing a colleague or a manager or a supervisor for making a defamatory statement. That is the topic of this episode of the Irish Law and Small Business podcast. Hey, it's Terry Gorry, and this is the Irish Law and Small Business podcast. I often meet employees who are involved in an investigation in the workplace or a disciplinary process in the workplace, and the allegation or the complaint might be against them, and they're so incensed and so angry that somebody would put such an allegation or make such a claim against them that they want to sue for defamation. They want to sue the other employee, perhaps a supervisor, perhaps a manager, perhaps a colleague on the same level, and they, as I say, want to sue for defamation. That is not going to happen because the legal position is that the vast majority of employment investigations and disciplinaries and statements, witness statements taken in those processes, in those procedures, enjoy qualified privilege. Qualified privilege means that the statements are made as part of a duty to share information, perhaps with an investigator. So the employee has a duty to share information with the investigator, and the person conducting the investigation has a duty to receive the information, perhaps the employer or on behalf of the employer. Bottom line is, the employer has a duty of care in the workplace, has certain obligations to prevent discrimination, to prevent bullying, to prevent harassment, to prevent sexual harassment, and so on. And in that context, if the complaint is made by an employee to an employer that they are being bullied or being harassed or sexually harassed or something of that nature, they're the victims of some inappropriate treatment. And it may only be a dignity at work complaint or grievance, but the employer does have a duty to investigate, and as part of that investigation there may well be statements taken and made and so on, witnesses, and as I say, the whole situation will probably almost certainly be qualified or covered by qualified privilege. Now, there is a definition of qualified privilege set out in the Section 18 of the Defamation Act 2009. I'll stick it up on the screen there, but you'll see that it shall be a defence. You'll see there in 18 subsection 2, it shall be a defence to a defamation action for the defendant to prove that A, the statement was published to a person who had a duty to receive or interest in receiving the information contained in the statement, or the defendant believed upon reasonable grounds that the said person or persons had such a duty or interest, and the defendant had a corresponding duty to communicate or interest in communicating the information to such person or persons. Now, qualified privilege may be lost, may be set aside if a person makes a statement or statements in bad faith, and if they make them with malice. But if they engage in a workplace investigation or make a genuine complaint or make a statement or a complaint or an allegation in good faith, then they will be qualified, or they will be covered by qualified privilege, and therefore the person who comes to me saying, I want to sue him or her for making these statements about me, they're untrue, I want to sue for defamation, why can't I? The likelihood is almost certain workplace investigations and disciplinary procedures would be covered by the notion or principle of qualified privilege. And as I say, there's a common law aspect to it, and there is a statutory basis for it arising from the definition of qualified privilege in the Defamation Act of 2009. And in relation to privilege, there's qualified privilege. There's also a thing called absolute privilege. And TDs in Dáil Éireann, for example, have absolute privilege. They can stand up in the Dáil, and in the Dáil chamber, they have absolute privilege to say what they like. And they can make statements which would be libelous or defamatory outside the confines of Dáil Éireann. And that's why sometimes you might hear a politician saying that if he or she repeats that outside the chamber, I'll sue for defamation, etc., etc. But the reason for that is TDs can say what they like within the confines of the Dáil chamber because they do have absolute privilege. The reason for that, I suppose, is that politicians should be allowed to speak without fear of being sued for defamation on issues of matters of national importance and so on. But sometimes it can happen that a politician can abuse the privilege, but we won't stray into that situation, that scenario at the moment. From the point of view, though, as I say, of the employee coming to me, or if you're an employee and you feel hard done by, you feel a statement made against you is completely untrue and there's no foundation or basis to it, the likelihood is that you certainly cannot sue for defamation because the other employee is entitled to make a complaint, he's entitled to have that complaint investigated, and the employer is entitled then to carry out an investigation.
Thanks a lot for listening, and don't forget to subscribe so that you won't miss an episode. And I'd really appreciate as well if you'd leave a review on the Apple iTunes store. Thanks a lot.